Hello, I'm Nicholas Svirnovsky, immigration attorney, and today we are going to discuss some changes in the migrations law. As you may know, the current government has launched a big reform of the migrations law as well as the citizenship law. In this video, we are going to treat some changes which are essential for those considering applying either for residency or for citizenship. First of all, for those wishing to apply for citizenship that are in the process of waiting for their residency to be awarded, you have to know that the Precaria certificate, the moment in which you are holding the Precaria certificate, won't be considered valid at the time of applying for citizenship. This is essential. Why? Because usually, especially with the last legislation, people used to think that by the fact of having the Precaria and having started the process of residency, this was going to be taken into account when applying for citizenship. Unfortunately, the new law of migrations is clear that this period won't be considered either for permanent residency and either for citizenship application, okay? What are other changes? Well, some other strong changes, especially for those wishing to apply for permanent residency, are, for example, the conditions for applying. In the past, it was enough either to be married or with a civil union with an Argentinian citizen or with a permanent resident. Nowadays, this is not possible anymore, okay? To apply for permanent residency, there are two options. First, to have lived here the period of time a temporary resident is required to live till it can change its status, which is 2 years for South American people and 3 years for extra South American people, and being Brazilian, as we have a treaty with the Republic of Brazil of mutual permanent residency. Okay, so to recap, now applying for permanent residency won't be valid for those having a child in Argentina, or for example for those who just have married an Argentinian citizen. Okay, for those marrying an Argentinian citizen, having an Argentinian son, or for example, doing a civil union with an Argentinian citizen or permanent resident, these people will be issued a temporary residency of 3 years. Okay? So now, unfortunately, you are not going to be able to apply for permanent residency straightforward, but the law will allow you to apply for a temporary residency for a period of 3 years. What is a possibility afterwards? Well, after staying in Argentina for those 3 years, which don't have to be continuous, but most of the time you need to be in the country, especially in order not to lose the residency, what will happen is that you will be able to change the status of your residency, okay? We are going to be able to become a permanent resident after 2 or 3 years, okay? Other of the changes which are extremely relevant is the period a person can stay in another country, so out from Argentina, to keep the residency, okay? Nowadays, with the new law, this is really strict and it is important to be aware of this, okay? If you are a permanent residency holder, you cannot stay out from the country for more than 1 year, okay? If you stay in the country out for a year, you will lose your residency. What happens if you're a temporary residency holder? If you're a temporary residency holder, you don't have to stay out from Argentina for more than 6 months. It doesn't matter if your temporary residency is issued for 1 year or for 3, you cannot stay out of the country for more than 6 months, okay? If you do, you will lose temporary residency and you will have to do the application all over again, which is a bureaucratic process indeed. Some other essential changes to the migrations law are, for example, the conditions for entering and applying for a residency, okay? People applying for residency will have to do a declaration, and at the same time will have to show a health insurance at the moment of applying. This is extremely relevant because in the past it wasn't asked, but now it's an essential requisite. It's an essential requisite. That means that by the time of applying, you should be aware that you have already hired a health insurance in order to have it at the moment of applying, okay? This can be seen in Article 34 of the Migrations Law. Let's read it together. In order to enter the national territory, foreign nationals requesting admission under any of the immigration categories provided for in the current regulations must submit a sworn statement declaring the purpose of their entry, affirming that they have health insurance to cover their medical needs and meeting the other conditions established by the regulations. Another important change that arises from Article 54 of the new law is the obligation to constitute a domicile, okay? To constitute an address which will be valid in terms of having notifications, so getting the notifications from the migrations office. This was already compulsory in the terms of the old legislation, but now it has been more precise, and it says that if you change your address, you have to communicate that to the migrations office within a period of 3 days. That's only to be more strict in terms of having the person notified if there are any changes in their process of becoming a resident in the country. There's another change in the law which is relevant, but is not specifically in the migrations law. In fact, it is established in the education law, okay? But it concerns the migration, okay? I have been frequently asked in the last days if residents, temporary residents, will have to pay for education in state institutions. Well, the answer is it depends, okay? For permanent residents, it won't be compulsory to pay. In fact, the modification in the law says clearly that nationals and permanent residents won't be asked to pay for education in state-owned institutions. What happens with temporary residents? Well, in that case, it is slightly different. The law doesn't say that you are not going to pay, but the law doesn't say either that you will have to pay. What the law says is that by being a temporary resident, a person is subject to pay eventually fees if the institution decides so. That means, for example, that if you are studying at University of Córdoba or Universidad de Buenos Aires, what can happen eventually is that if the university decides to charge you a certain amount for the education service, you will have to pay. But if the institution doesn't do so, then you can continue studying without paying any tuition fees. Let's talk now about some citizenship changes. We have already talked about migration, permanent residency, temporary residency, but we haven't spoke about citizenship process. This is probably what has changed the most. During the last years, Argentinian citizenship law was Law 346, which was a really old law created at the really beginning of the Argentinian Republic. With these modifications, the substance of the law has changed in a broad way. First of all, for those having an Argentinian kid, for example, or being married to an Argentinian citizenship, they have to keep in mind that they won't be allowed to apply for citizenship, unfortunately. What the new law says is that a person could apply for citizenship if she or he has lived in the country for 2 continuous years, that means without going out before the application. Okay? It doesn't say though what will happen with those, for example, that have been living in the country for 10 years. Okay? At the same time, there's people that have stayed in the country for 3 years and then started traveling. So this will be subject of evaluation during the new processes that will be started. Okay? Something essential in terms of the changes in citizenship law is also that the process is not going to be a legal process now. It's going to be a process done through the migrations office, just like the residency process, okay? In the past, it was a legal process at the civil and commercial courts. Now this has changed radically, and the processes are going to be taken by the migrations office. So the citizenship will be awarded to the applicants by the migrations office, okay? And if everything's well, after awarding the citizenship to the person, they will also give the person the national ID, okay? Those are the key changes in terms of citizenship. So to recap, if you expect to apply for citizenship because of having an Argentinian kid or being married to an Argentinian citizenship, you have to know that this isn't possible anymore, okay? You could either apply for a temporary residency and then eventually become a permanent resident and apply for citizenship, okay? Please keep in mind that I always recommend applying for temporary residency and then permanent residency to show that you actually have an attachment to the country when applying for citizenship, okay? Also, something important to keep in mind is that in the past, someone staying irregularly in the country could stay and eventually apply for citizenship. There was jurisprudence that accepted this. Some judges awarded the citizenship to people that weren't living in the country legally. Nowadays, this is not possible anymore. Not only because the process is not going to be a legal process, but also because the law now is clear and says that the person must have lived in the country for 2 continuous years under a legal qualification, okay? So under one of those legal residencies established by the law. So if you are considering applying for residency or citizenship, I strongly recommend checking the requirements. Remember that it is not necessary to have a lawyer when applying for residency or citizenship, but it is highly recommended not only to deal with the legal terms, which sometimes can be complex, but also to skip as much bureaucracy as possible, and at the same time to have certain assistance if an appeal, for example, is needed during an application process. I hope this information was useful for you, and if you would like to contact me or hire me to take your case or to consider taking your case, please don't hesitate to contact me through my personal page. Thank you very much, and see you next time.